It has everything to do with Obamacare and whether or not companies should be forced to provide contraceptive as part of their health care plans. We have Ken Klukowski on the line. He's a constitutional lawyer and an analyst for Breitbart News. An all-around good guy. Ken, how are you?
Good morning, Brian. Doing great. Hello, Larry.
Hey, Brian.
All right, so let's talk about this case. Now, this is based on a case that has already made its way through the appeals court. Bring us up to speed on where the case came from and what's at stake here.
Absolutely, Brian. There's actually two of them. Of course, your listeners know about the HHS mandate that a plain vanilla provision of the Affordable Care Act of Obamacare saying that employers have to cover preventive care. HHS Secretary Kathleen Sebelius issued a regulation saying that preventive care includes birth control and abortion-related services, including birth control medications that actually cause abortion, creating an exemption only for houses of worship. Then, of course, you have businesses that are owned and run by devout people of faith, evangelicals, Catholics, etc., who objected. We've had a couple years of litigation now. One of those is the Hobby Lobby chain, which is owned by the Green family, who are evangelicals, excuse me, who were facing a fine if they refused to go along with this. The penalty under this regulation, authorized by statute, is $100 per employee per day. So for Hobby Lobby, that meant a penalty of over $1.3 million per day.
Wow.
That they refused to cover abortion-related services. The lower courts held that this violated Hobby Lobby's rights, the rights both of the Green family and the right of their wholly owned business to be conducted consistent with their Christian faith. That is now a violation specifically of a federal statute called the Religious Freedom Restoration Act, of course, or RFRA. Even if you didn't have RFRA, then you would get to the issue of whether it violates the Free Exercise Clause of the First Amendment of the Constitution's Bill of Rights. That is one case being represented by the Becket Fund for Religious Liberty. The exact same issue is with another company called Conestoga Wood Specialties, represented by the Alliance Defending Freedom. In that case, the lower court said that this did not violate religious liberty. So the court had to split between the 10th Circuit Appeals Court in Denver and the 3rd Circuit Appeals Court in Pennsylvania, and they have taken both of these cases, consolidated them before the U.S. Supreme Court.
All right. That's a very good assessment of what's going on. But so when you have two courts that are split like this, it ultimately just pretty much has to go to the Supremes, right? You can't leave that kind of dissonance in the law.
Ultimately, Brian, except that you can have a circuit split that endures for many years before the Supreme Court takes it. Sometimes it even waits until there's a three-way circuit split. The country is divided into 12 federal appeals courts. And, in fact, there were 4 cases offered to them this week. There was another one from the 6th Circuit, which is in Cincinnati, and yet another one as well. And so there was one from the 4th Circuit in Richmond, and now recently another case was decided by the 7th Circuit out in Chicago. So there are multiple cases going on out there. 4 of them were offered to the court yesterday. They chose to take this too. But I'll tell you, even with a circuit split, you usually have to be creating an issue of national importance before the court takes it. The court is offered 8,000 cases a year, and they only take 80, so they're very selective on which ones they take.
Ken Klukowski is our guest, constitutional lawyer and senior legal analyst for Breitbart News. And, Ken, I've been reading a lot of analysis of the court's decision to take up the Hobby Lobby case, but I decided not to, believe anything that I read until I heard it from you. And so you tell me what to think about this. So tell me, I've read that some people think this is a chance for Chief Justice John Roberts to rethink his position on Obamacare. This is in a climate where, the Supremes see what's going on in the news and they see all of the trouble people are having because of this law. Could their decision reach beyond just this one very narrow item and actually put a huge dent into the Affordable Care Act?
Well, Larry, as a constitutional conservative, I don't think I have the right to tell you what to think or believe. That's kind of what the Obama administration is doing.
I give you permission, though. You would not impose that on me.
Thanks so much. This is as impactful as this is actually just a regulation issued by the federal government. If they strike this down, it will not touch the words of the Affordable Care Act itself. Now, it will have a huge impact, a tremendous impact, on how Obamacare affects many thousands of religiously owned businesses nationwide. So the impact will be enormous. I have to say, as someone who has been involved in a number of religious liberty cases argued before Chief Justice John Roberts, I'm actually confident that there are 5 votes before the U.S. Supreme Court to strike down this HHS mandate. This is such a gross violation of religious liberty. It really is not a difficult case in that regard, and right. I believe there's at least 5 votes to strike it down. Argument should be in March or April with the decision before July.
Can I ask you, though, Ken Klukowski, obviously I understand the First Amendment and the religious aspects of this. I have a lot of friends who are religious and business owners, but I have a lot of friends who are non-believers, who are either agnostic and atheist, but they're conscientious objectors against abortion. You don't have to be religious to be against abortion and to be pro-life. What about those people who may not claim religious liberty, but just say, you know what, this violates my understanding of
my sensibilities
and my moral basis?
That gets into more of a gray area of the law, because the issue is you do have this federal regulation out there that carries the force of law, and the question is what trumps that? Now, you have this Religious Freedom Restoration Act, which specifically refers to government action, federal government action, which imposes a substantial burden on a person's religious faith. Now, the courts there are to be completely deferential in terms of what is part of a religion's teaching. Is this a sincerely held religious belief? You know, is abortion really a big deal for Catholics or evangelicals? That's the kind of stuff that a court is not allowed to ask. But RFRA nonetheless does refer to religious faith. Now, if you get broader out there to issues of conscience, we do allow conscientious objectors, or I should say we respect conscientious objectors on issues like using lethal force in the military, but certainly under the free exercise clause of the First Amendment and under RFRA, you're really in a gray area, and I have not seen. I've been involved in a number of these cases. I've never seen a court rule one way or the other on someone who says I have a true conscientious objection here, but I'm not calling it a religious objection.
Ken Klukowski, we've got to leave it there, but you're always so thorough. Thank you so much
awesome
for joining
stuff.
us.
Thank you, Ken.
And happy Thanksgiving.
Happy Thanksgiving.
Absolutely.
Thank you,